everybody on Zoom. So we may have, the door might open, you might have somebody group in. Graham, you'll have to pronounce your last name for me. I apologize. I'm not the tip of my tongue yet, but.
That's fine. It's Unangst Rufenacht.
Rufenacht. Okay. Graham is here to give us a little bit of context for some changes that are happening to a bill. It's not our bill, but could come our way. H270, which is the miscellaneous cannabis bill. We passed it out of the House a while ago, and it went to the Senate, and they've been doing some work on it. And we did have Michael Grady come in and give us a heads up, and we did actually look at the language that at the time was maybe the Senator Ag's language. It might be what you and I were discussing earlier. In any case, we wanted to, rather than look at the language and go through that, just maybe hear a little bit of as I said, context, justification, background. We're somewhat fluent in current use, and that's the piece that, that's one of the pieces anyway that I think is affected. Mm-hmm. It would be of interest to us. So maybe you could start by just reminding us of the way that we left things last year when the House considered a current use exemption for cannabis, what that looked like, and so what it currently looks like.
Sure.
Be a good place to start.
So start with what it currently looks like and what's been included specifically around the ag exemption.
Yes.
Okay.
Sure. That.
And just to introduce myself formally, this is Graham Unangst Rufenacht, Policy Director at Rural Vermont, and member of the Vermont Cannabis Equity Coalition. I've also invited my colleague Jeffrey Pizzatillo from Vermont Growers Association, also a member of the coalition, to come in case he can respond to any of your questions or respond to things that I'm not able to respond that well to. So we have been advocating with this Vermont Cannabis Equity Coalition since 2020, but our organization even as far back as 2016, about this issue and just sort of the importance of agricultural access once this does become a regulated marketplace. So last year, what was done in statute was to enable tier 1 outdoor producers, these are 1,000 square feet or less or 125 plants, give them some of the allowances that agricultural producers have under law. This included access to current use if you were already enrolled in the program. So for example, if you were a small vegetable farmer and you had your portion of land in current use, and you were going to grow cannabis, you wouldn't therefore have to pull part of your land of current use. You could just maintain that in current use status. The second aspect was tax exemption. So you can imagine sort of some of the challenges with a farmer who has X, Y, or Z implements that they are supposed to only use because it's tax exempt for their agriculture as opposed to their cannabis. That was included for tier 1. The third exemption, I did current use, I did tax exemption.
Was there an Act 250?
Municipal bylaws?
No, well, yes, municipal bylaws. That was the third one. Thank you for asking. Municipal bylaws. So that just simply like most agriculture, municipal bylaws could not, really didn't have any sway over outdoor cannabis producers of that tier. So our
that tier, can you just how that was defined, that tier?
That tier is tier 1. It's 1,000 square feet or 125 plants. So when you choose what you want to be as a tier 1 producer, you can choose either the square footage or the plant number.
And those two numbers were intended possibly to be roughly comparable in terms of you could grow 125 plants in 1,000 square feet. Was that the...
That'd be a question for the Cannabis Control Board because they articulated that in rules. What our coalition had always been advocating for was essentially a 1-to-4 ratio. For every 1,000 square feet of indoor grow space, an outdoor producer should be allotted 4,000 square feet. And across the nation, that's actually now grown to more of a standard of 1-to-6. Simply because it's been acknowledged that you can grow so much more indoor space than you can in an outdoor space. And there's so many more vulnerabilities seasonally and otherwise to what you can do outdoors. But that is not actually what it looks like in Vermont when you look at the scales. So I would say you just have to talk to the Cannabis Control Board to get a better idea of why that was articulated in that way. So this year, and I would say, our coalition, Rural Vermont, for a long time has been saying that essentially the state should do everything it can to treat all outdoor production in the same manner as agriculture, in as much as we can as a state without coming into conflict with the USDA's equal to status for our agency of agriculture and for the state. So it's always been our position that it shouldn't be relegated to a tier one, that any outdoor production should be considered in this way. So this year, when H270 got to Senate Economic Development, the Cannabis Control Board went before them and essentially made this suggestion that this should be extended to all tiers and types of outdoor production. And the question was then sent to Senate Agriculture as to, basically, I think Senator Clarkson, who is more or less in charge of that committee, while Senator Rahm is having her child, tried to disperse to committees of expertise some of these different matters. There had been testimony in Senate Agriculture earlier this year from a couple of producers, former Senator John Rogers, a farm in Charlotte, about some of the challenges related to being a farmer and also trying to be an outdoor producer of cannabis related to not having these exemptions being higher than a tier one. So some of the reasons that these are being considered, and you asked this question before, is because there are a number of conflicts coming up. So under current statute, it's stated that municipalities cannot prohibit a cannabis establishment other than retail from operating in their area, but they do have their normal powers of zoning. But this became a point of contention between certain municipalities and producers and the Cannabis Control Board, in that there's some different legal interpretation of how that can look. Because if you tell a town they can use their zoning, well, then theoretically they can zone cannabis in different ways. But if you tell them they can't prohibit, it sort of says, well, are you having the effect of prohibiting a license by exercising your municipal power in certain ways? And that really wasn't clearly teased out in statute. And the Cannabis Control Board actually hosted a really interesting call for towns and for producers to talk about this issue. And what became very clear was towns like the city of Burlington and others was very unclear on what they were actually allowed to do or not allowed to do in relationship to producers. And they weren't really satisfied with the statute in terms of defining what that did or didn't mean. So, for example, in the town of Charlotte, we have a producer who has been producing organic vegetables. They've been producing hemp for a number of years. They produced cannabis last year. They're a tier 3 outdoor producer. The town was essentially saying, putting in zoning regulations which would functionally prohibit them from continuing to operate. They put in setbacks, and I could show you the map. I had their permission. I would show you the map they sent me that essentially cut off all of their high tunnels and glass house from the production zone, leaving a tiny narrow piece because the property boundary setbacks are just such that it for them as small farmers, it cut back the area that they were going to grow in. They functionally couldn't grow. Another aspect that Charlotte tried to do is say, well, the smell of this plant can't leave the boundary of your property. And that's functionally out of their control. And the reality is they've been growing hemp there for multiple years. And as you know, we have acres of hemp growing across the state of Vermont, and its odor is not regulated. So there's also the question of, well, functionally, how could someone differentiate the smell of a hemp plant from a cannabis plant? And how would a regulator or a court, make a decision like this? So this question of municipal governance was brought up again in Senate Agriculture. What Senate Agriculture determined to do was to, yes, expand the existing exemptions to all tiers and types of outdoor producers, and to include 2 supplemental ones, one including Act 250 and one including the nuisance protections and the right to farm law. Nuisance protections get right to that odor question, as well as some others that we can imagine. And the Act 250 is essentially, again, as we said, to do as much as we can to treat these outdoor producers in the same manner as agriculture. So again, it was just a question of why do we want to, for example, why would we want Act 250 to be able to regulate the outdoor production of cannabis became a question. And the consequences of regulating it through Act 250 seem to be much more consequential than the consequences of not regulating it with Act 250 in terms of the burdens on small producers and producers more broadly. And it's a question, is it development or is it agriculture? And how does the state want to see this? Another piece of language that was changed in the Senate was essentially, and I'm sorry I can't walk you through the language. I'm sure it'd be easier if you had it in front of you, but you do have it. It's out there and you can look at it. another change that was made was to essentially that language which says towns cannot prohibit the establishment of a cannabis license. They added more language to say that towns also, I don't know exactly, but towns essentially cannot functionally prohibit as well. And that the Cannabis Control Board would have some, relationship to determining whether or not a town has transgressed its legal boundaries. And that is, there's another part of the bill from an agriculture perspective called establishing a propagation license. There hasn't been too much discussion around that. It basically allows someone to sell seed, starts, immature plants to the public. I'm sorry, not to the public, only to licensed cultivators. Our coalition has advocated strongly that it include the public. It does include seed sales to the public, not immature plants. And we've been relatively frustrated, I would say, with the Cannabis Control Board's response. And I would love the opportunity to talk about farmers calling me and asking about selling plants to the public or have some of them come in. But I think that's another conversation. I'd be happy to have it with you if the bill did come back to you or if there was a committee of conference where that seemed like a point of conversation. I think that's relatively it from an agricultural perspective. I mean, I think certainly the social equity work and the caregiver allowances and all these other things are related to this and have intersections with agriculture. And if you'd like me to speak more to that, I'm happy to. But I think what I spoke to is probably what you wanted me to speak to in here, and I can answer more questions about that if you'd like. And Jeffrey, if you'd like, you're welcome to invite Jeffrey to speak to anything I may have missed.
Let's see if there's any questions based on what you've said so far. Yeah, Representative O'Brien.
Can you just take us through the tiers? Talk about 1 and 3, but how many, those sort of parameters?
Yeah, actually, I don't have it right in front of me, but somebody might know them better.
You want to come on? There's another chair.
I can get one for you.
Hold on.
Thanks, committee. For the record, Jeffrey Pispillo, co-founder and executive director of Vermont Growers Association. We're 501c4, we're the trade association for this emerging cannabis industry. So though we have growers in our name, our members represent the entire supply chain. So there are 6 tiers within each cultivation category that the agency established. The 3 cultivation categories are indoor, outdoor, and mixed use. The 6th tier has not been activated by the CCB. It's within their authority to sort of activate or sunset tiers. So the largest tier that they defined, which is tier 6, is 37,500 square feet outside or 4,687 plants. Indoor, it's 25,000. And so those aren't available. So it's only tier 1 through 5. So I'll step through them very briefly. Tier 1, as Graham mentioned, is 1,000 square feet or 125 plants that's outside. Tier 2 outside is 2,500 square feet or 312 plants. Tier 3 outside is 5,000 square feet or 625 plants. And tier 5 outside is 20,000 square feet or 2,500 plants. And very briefly, it was asked a moment ago where the plant count sort of equation or formula came from. That came from the CCB determined an 8-foot diameter for each plant. So if you look at the plant count for the outdoor tiers and multiply that by 8, you'll get the canopy. So that was roughly a 4-foot plant with 2 feet around it. Anyway, so that's 8 total. So indoor tier 1 is 1,000 square feet. There's no plant count. Indoor tier 2 is 2,500. Indoor tier 3 is 5,000. Indoor tier 4 is 10,000, and indoor tier 5, which the CCB just sunset in their board meeting this past Monday, is 15,000 square feet. I'll stop there if there's any questions.
So tier 5 has been sunsetted for indoor, not for both outdoor and indoor.
Correct, just indoor specifically.
Okay.
Yeah.
And just to clarify, so all the language I walked you all through is explicitly just for the outdoor production. So all the indoor is still would be considered under the category of development, regulated by municipalities, regulated by Act 250.
Another question? Representative Rice?
What's the, doesn't have to be exact, but what's the sort of breakdown or distribution of growers over those tiers right now?
A majority of them that are approved for licensure are tier 1 through tier 2, and that's for all categories. There's a handful of maybe like a tier 4 or tier 5, that kind of thing. And I think that there's a moderate amount sort of filling in that with tier 3. But largely speaking, the board approved tier 1 and and just to give everyone an example, there's about 300 approved cultivators. So that's the size that we're talking about, of about 400 approved licenses to date. So the majority of them are cultivators, and of those cultivators, the majority of them are smaller tiers.
And I would just say that Bryn Hare from the Cannabis Control Board in Senate Economic Development, I think it was yesterday morning, spoke to these exact numbers and actually spoke to the total square footage that these folks currently take up in the state and sort of what the consequences would be from a current use taxation perspective or from a sales tax or X, Y, or Z perspective about what it would actually be like from a fiscal impact, from a landscape impact, et cetera. I believe she said something like, given the current licensees, you'd be bringing about 8 more acres in the whole state potentially under current use. So we're not talking about
Tier 5 outdoor, you mentioned, Jeffrey, was how many feet again?
20,000 or 2,500 plants.
So
Half an acre.
I was going to ask somebody to try and translate 20,000 square feet into acreage. So a half acre.
About 47% of 1 acre.
Amen. That's right. A little less.
I flung that.
So the current use program has criteria, eligibility criteria. One of them is you can either have a certain number, I think it's 25 acres or more to be eligible. And then alternatively, if you have half of your income, household income from farming, you can qualify. Maybe this isn't your area of expertise, Graham, but I'm thinking that, so we've just learned that tier 5, largest tier there is, or the one that's in business anyway, is only half an acre. So nobody's going to qualify with the 25 acre rule unless they've got existing land, which they already do qualify for under part of the existing rule. Okay.
Well, both of those are important. It was both important for existing farmers who were putting a small amount in to be able to continue to be in current use. And actually another part I left out that was amended, this was based specifically on a request from our coalition, was to take out the provision that said if you were already enrolled in current use. Because our feeling was that we have a lot of beginning farmers. We have a lot of people who don't currently have access to land. And to basically tell someone who just got a piece of land that, well, your neighbor who might be growing cannabis because they're already in current use gets to keep being in it, but because you are a new farmer, you can't enroll or enlist, didn't seem at all equitable from our perspective.
So,
and the board, Cannabis Control Board supported that, and it was included by Senate Ag.
Just thinking about the second piece of the existing requirement to be enrolled in current, the existing option to be enrolled in current use, having 50% or more of your income be from farming. If we adapted the changes, then it sounds like are working their way through the Senate. Do typically the members who you represent, for example, Jeffrey, are they earning? Would they be earning half of their income from sales of what they're growing on the half acre?
That's a good question. I think it would vary, but I'll say this: cannabis is a high yielding crop compared to other crops. So, like the revenue stream would likely be, I think, substantial compared to most other crops. So, and that's often why you see, in general, a lot of, for instance, farmers in the state moving over to it, but for other reasons as well. But I would say predominantly, just without having a concrete answer, yes, absolutely, should be a livelihood for people.
And I would just say to get some clarity from Legislative Counsel Grady, perhaps he was going over the difference between the 25 acre plus and the under 25 acre qualifications for the current use or the value use appraisal program.
Yep.
And I can't remember if just qualifying for a farm, meaning that more than $2,000 in gross income was a large enough, was also a qualifier for the under 25 acres.
Might be.
Yeah. In it. Yeah. Go ahead. Sorry.
Am I right in saying that the CCB has cut off taking applications for cultivation, I think the end of this day, if I'm not mistaken?
They
freezing.
Yeah, so about a month ago, the CCB voted during one of the regular board meetings to create a seasonal closure window for specifically outdoor and mixed use new licensees. So renewals may be processed during that time, but this seasonal closure, I believe, is Today, it begins 28th at 4:30 p.m. And don't quote me, but I believe it opens back up December 2nd. And so during that time, no outdoor or mixed use new applicant will be received by the board, only renewals. Yep, and they have a couple reasons why they did that.
And you want to share them or?
I think one of them was, two primary points to impart, I guess. And I would allow that agency to speak more comprehensively, but from our understanding is bandwidth is a concern within the agency. So just the capacity to turn out. And so, they were looking at just the practical nature of someone wanting to apply for a license, say mid-season, and having plants in the ground or not, and sort of whether or not that's realistic, and then determining, maybe we can shave some of our own bandwidth and allocate it elsewhere. So that's one aspect, bandwidth. Another aspect was that we're aware of was supply and demand. So trying to just ease into a little bit of less of allocation of supply.
And I might be wrong, but I believe another thing they spoke to is that in the first year, last year, they felt flexible with allowing people to come into the program throughout the season, already having planted plants, as in operating without a license to some extent. And that this year they said they didn't feel like they wanted to sort of provide that flexibility or allowance anymore, and they wanted to have a clear cutoff. Was that sort of something they mentioned?
I believe that may have been something that they articulated as well. So like last year, they afforded sort of like an initial transfer, if you will, or they're sort of very forgiving of, and this was the intent behind it was to help transition legacy cultivators. So if you have a crop already, kind of thing.
And acknowledge the challenges of the application process, where people could be waiting for a long period of time to actually get approval and have to make a choice about, well, I have to plant.
Having been through it once, in theory, the legacy growers would already understand what it involved, and they wouldn't need another year, perhaps. How much of a notice was there given about this deadline today?
I believe it was at least 60 days. I think it was definitely within, they were following their own procedures. Yeah.
I don't think it was a decision that our organization supported necessarily, but
We do oppose that decision.
And we'd be happy to hear more about that if you care to, but I'm not sure it falls within our purview necessarily. Representative Lipsky?
Yeah, first of all, I apologize to my committee and the witnesses for being late. Second time in 4 months, I left the property to go to lunch and got lost in the city there. Anyway, few questions, and I apologize if I've already answered them. And they mostly have to do with equity for Vermonters who, how many folks are licensed growers, outdoor?
specifically outdoor versus indoor.
Yeah.
Did you have any of those numbers in front of you?
What I can say is of the about 400 total applicants that have received licensure, about 300 of them are cultivators. I can bring up that breakdown that's in front of me.
And, I don't know a lot about cannabis, unfortunately, but it seems to be for other farming crops or growing crops, sense is that it's profitable as opposed to a lot of, farmers or landowners are struggling to hold on their land. So it strikes me, I'm curious how much it costs to get a license to do this. And, when, the notion that it was legalized in Vermont to grow, were there local Vermonters who actually got into this, or were there people who came from, flooded into town or the state to take advantage of this emerging market, and how equitable to shut it off to leave the little landowner trying to hold on their farm shut out of they didn't jump in this first season.
You mean the application process?
Affirmative.
I mean, it certainly closes the window for access. I'm sure, I think in terms of the cost of different tiers, I'm not sure if Representative Templeman, knowing that you've gone through the process for as a tier one producer, you could probably speak to that pretty accurately. But there are, for example, costs from the state, and then there are other costs. This is insurance and banking, costs for registration of product, et cetera. And for example, I even had a conversation, someone ran into me in the co-op the other day, I got to send your organization an email. I've been saving up for a year to, hopefully get into this. I've been producing my whole life. I've decided $8,000. This is she's a goat farmer, a very small goat farmer who's been working in the co-op a lot of her life, and explained to me that because she had to replace her car this winter, she didn't realize all these other costs, that the banking costs, that the insurance costs, that some of the other costs were so exceptional. And now she's gone through this whole process to get the license, because the license, I think, for a tier one is $750. So it seems reasonable. And then sort of confronted the reality at the back end of what this meant. And this is also, people learning how to run a new type of business. There's a lot of new requirements with this that are not like when you're running a small business of any other sort. But I'm not sure, Jeffrey or Representative Templeman, if you want to speak to costs.
Yeah, I mean, if we're planning for this year's crop, I'm a tier one outdoor license holder. It set me back about 20 grand. I mean, all things in.
Big deal.
Yeah, that includes my lawyer, insurance, a certain amount of time involved, gasoline, driving to places. I mean, all in 20 grand. Yeah.
And that's a tier one. So that's the 125 plants or 1,000 square feet of production. So that's the baseline, sort of most accessible scale of licensure.
So 1,000, not thinking acres now, but 1,000 square feet, 30 by 30 would be 900 square feet. So a footprint of what?
The house, it's
30 by 30
a
would be
little over a
house.
50th of an acre.
Got that. Okay. Are you Representative O'Brien?
And just ballpark, what's outdoor grow, say, what does one plant realize,
Depends on methodology. I think 2 pounds is pretty average for an outdoor plant. I go for very large plants. So I'm looking at like 6 to 7 pounds per plant. But that's methodology again. So I'm not doing 125 plants. I'm doing 50 large plants rather than 125 regular size plants.
And the market is what per pound?
Right now, these gentlemen may be more up to it than I am, but about 2,000 to 2,500. Yeah.
2,000 to 2,500 for roughly like really nice outdoor full sun and mixed use, and then closer to 3,000 for some average indoor grown flower, which is on average for adult use markets across the state.
Those prices wholesale on bulk, or have you done value added like processing yourself and packaging?
That would be, so I'd say 2,000 is probably bulk. Yeah.
Is that wholesale or retail?
That's wholesale.
So producers aren't allowed to directly retail themselves. And I would just say in response to this that, what we've seen in other stages at this initial stages of a market, there's typically a little higher prices while people are getting more involved, and then the prices can rapidly bottom out depending on how consolidation and centralization, work in the state. So what we're really just trying to do is preserve, recognizing these prices are going to drop at some point. We're trying to preserve a middle ground where we're not, flooding the market, but also not having a place where, as you said, we're really inviting in actors who just come with a lot of capital, a lot of resources, and can use that to consolidate the industry, which is why we were really satisfied that the CCB closed the, I believe, tier 5 indoor license, because we just felt like the scale of that production was sort of out of proportion with the state of Vermont's goals. See, I'd say also the state of Vermont has done some good work in that respect by limiting what's called horizontal integration, meaning that an actor with a lot of capital couldn't come into the state and open 5 retail businesses. They can get 1 retail business license. They can get essentially only 1 license of each type in the state. And that limits, I think, a lot of consolidation that we've seen in other parts of the country and around other industries.
I've seen concern regarding, let's call it subcontracting, where, a big multi-state operator will contract a license holder cultivator to represent their product, and then they'll put their name and branding on a product that is grown by a licensed cultivator, but they are not themselves licensed in the state of Vermont. Have you come upon that, and is the PGA have an opinion on that?
So would you characterize it as white labeling, or is that more like a licensing agreement kind of thing?
I'm not sure actually what white labeling even means.
Okay.
Sorry.
Gotcha. No problem. No problem. So like white labeling is an instance where, for instance, we have manufacturers, it's a license type, and they're allowed to make like edibles and various concentrate products within the THC caps. And so what's common is retailers may want to have like their own store label, right? But they're not manufacturers themselves. So you can have you can pay you can get a manufacturer to produce a product labeled as such as, and you see this in grocery stores, right? And any other sort of like sector. So that's sort of white labeling is that in the cannabis.
I don't mean that.
Okay.
That seems acceptable to me.
Sure.
If all parties have a license.
Sure.
I'm talking about like Ben Cohen, you know, coming in with his multi-state brand.
Sure.
He doesn't have a license, but he's like working with people who do, and then he comes off with a little check at the end of each month.
Sure. You know, I would say it depends on how these entities carry themselves. You know, my response would be, we have large cannabis entities in the state. We have had them since about 2007. They're in our medical industry, right? And those market actors receive what we call in the industry first mover advantage in our enabling statute. You guys may have heard this 5-month window. So they were given sort of statutorily a little bit of a heads up for whatever reason in our adult use market. So I would add, you know, that is our more of a concern for our organization and our members and our small producers than, you know, what may be emerging. And I think it's important what you raised, but we would need to, you know, see how that plays out.
And I believe there are provisions that the Cannabis Control Board put in place around ownership. 51% ownership, and certain where stake must lie in terms of the licensees and the structure of the organization. But again, I can't speak to those regulations that much. The other thing I just wanted to say in relation to the yield question and what Representative Templeman was saying is that I think what's important to remember too with outdoor production is that you are really vulnerable to seasonality and to different things that roll through. You could have a crop where you may be expecting, you know, a gross income of over $100,000, and you might be leaving with negative because 3 years ago, was it? There was a deep freeze in Marshfield where I live on September 13th. It was a deep freeze. And if you weren't planning to have some device where you could cover your 125 or your 4,000 plants, you would have lost all of them. I had people calling me and they were looking at Heather Darby's research into hemp plants. You know, they were saying, I'm seeing 24 degrees as that limit that Heather's really established in hemp. Like, what should I do? And you don't, you know, depends on your microclimate. It depends on what your investment is, depends on X, Y, or Z. Do what you can to protect them because that's a big investment. But just to say that there are reasons that, you know, outdoor production, you know, it could be high yielding, and you could also deal with losing a lot of plants to a disease or to a insect vector or to weather events, hail, you know, all kinds of things.
John?
How far with value added can you go? Like, could a cultivator essentially end up with edible gummies, or, I mean, still selling them for wholesale to somebody, but.
I'll leave it to these two after I give my initial response, but I believe what I understand is the only value adding that a cultivator can currently do is manufacturing what are known as pre-rolls, which is, you know, rolled cigarettes, rolled joints of cannabis. And then they can sell those wholesale. But otherwise, anything else has to be contracted to a manufacturer. And it's actually the case that the producer can't even take it back into their possession after that. If they sell something back to a manufacturer for value adding, as I understand it, that must stay in the custody of that manufacturer. So you're really limited in terms of the value adding and your propriety in relationship to that product. But I'd allow you to, Jeffrey, was that correct?
That is correct. And that's one of, I guess, the items in 270 that I think is fantastic that's in there. There's a little bit of language that allows basically right now, there's a difference in statute between cannabis and a cannabis product, right? Cannabis product is an edible, hash, what be it, it's a broad category. Cultivators are not allowed to have in their custody at all cannabis products.
Oh.
So what 270 does, it relaxes that. So you can have a contract now, if this were to get enacted, where, you know, you can pay someone to, you know, process like your meat and you can get it back to you and you can sell it. So that's just logical. We support that. We're glad that's in there.
I think it's little things like this that I'm glad that we're in here talking about them because I think they're not really well understood throughout the legislature and even throughout the community of cultivators or manufacturers more broadly. And I think it's little things like this that we're really trying to tease out bit by bit to try to create a more equitable market that, mimics some of the safeguards we have in other marketplaces around direct producer sales, et cetera, and just having, allowing the CCB to make reasonable guidelines around that, but not prohibiting it.
We are planning to have the CCB come in sometime next week or during some downtime and we can ask some of the questions that maybe don't have the answers to, Graham, but I wanted to, and you may have already addressed this, but just in terms of what's already being grown, how much being cultivated, how much is indoor and how much is outdoor?
Again, I'm not sure we have the responses to that, but I know that Bryn would have that breakdown. Jeffrey, does that number, do they have that out there?
So looking at the CCB's last executive director report, which is something they publish with all of these metrics on a monthly basis, licensed is indoor canopy is 140,000 square feet. Outdoor is 468,000.
Oh, so like 3 times?
Yep, 140 to 468.
Outdoor, 3 times outdoor versus indoor, okay.
I would just add to that an indoor cultivator is able to yield a larger quantity because they can grow year round. I mean, I'm thinking that's probably a ratio of 1 to 2 as far as indoor to outdoor to being indoor.
So that was square footage that you just gave us, those numbers were?
Correct, that's square
And I just did that math, it's less than 11 acres of outdoor space at the 480,000.
And just keep in mind, that's what's licensed, that may not be utilized as well. So that's an important, I think, distinction there, especially for outdoor and mixed use, that's seasonal. But speaking to what Rep. Templeton brought up briefly, what we see in more sophisticated adult use states, and this is what maybe Graham spoke to earlier, it's like a cultivation ratio. It acknowledges 1,000 square feet grown inside is not the same as 1,000 square feet outside. Traditionally, in more sophisticated states, we see like a 1 to 4 ratio. That's what we had adopted here, and then that's now sort of bumping up to like a 1 to 6, 1 to 8 in some states. So just things to keep in mind. We are now currently advocating for a 1 to 8 year BGA, so that would be about 5,000 square feet indoors, what we want to cap that at. Our sizes, just so everyone's aware, like our canopy sizes are fairly moderate compared to other states. I mean, in California, you can have several 100,000, right, acre cannabis farms. In Massachusetts, their smallest tier is like, 5,000 square feet or something. Our smallest tier is very moderate sizes in this.
And we've supported that as well, I should say, and are supporting actually downsize the indoor grow even more because there's a potential for decentralization of wealth generation with this, we think.
Representative Rice?
Is there a target number of acres that sort of like have been pointed to as the appropriate amount of cultivation to support Vermont's market in the long term?
So the CCB hired an out-of-state firm during its initial rulemaking process to arrive at a modeling and analysis for supply and demand. And so I think it's important that they're not necessarily strictly following that so much as using it to influence their decisions. And they've been updating that modeling and analysis, I believe, once now. So it's been updated once or twice, I believe, since its initial development. And we've had some input, the board brought us into that initial process as well. And I believe they're looking at around 400 to 500,000 square feet total. That's what's coming out of that modeling and analysis on an ongoing basis. So keep in mind those figures that we just mentioned a moment ago aren't total utilization. It's just what's been licensed. And we think that, it's good to consider those models while also ensuring that we're doing things like arriving at our legislative intent to onboard the legacy market, things like that. So there's a balance there. So I hope that answers your question.
Yeah.
And was that broken out in indoor or outdoor? That
it is, yes. And that model of analysis should be available on the CCB's website.
That math works out to be 10 1/3 acres.
Right.
And I would say, I believe your organization sort of disputed that projection as well originally, suggesting that that acreage was probably already under cultivation in Vermont.
Correct. I mean, so our own data at that time, this was a couple years ago, we had sort of projected that the current legacy supply and demand is about 500,000 square feet canopy. So when we imparted that on the CCB, hey, we want to make sure we're including these individuals and not, for instance, making that overall supply and demand so small that we're preventing these people from onboarding. Yeah.
Any other questions? All right, thank you for coming in. Jeffrey, your organization, I think you said it was the entire supply chain. Do your members include those legacy 5 integrated growers? Are they part of the Growers Association?
The integrated growers, you mean like the medical dispensaries?
Yeah.
I just didn't understand the term legacy when you were using it and what it referred to.
Oh, okay. Apologies.
Well, yeah, go ahead and explain.
Certainly. So when I am using the term legacy today, and apologies for being confusing, I'm referring to like the black market, the illicit market, Vermonters who have been.
I did understand that. I think I misused the term. So what I was trying to get at was the integrated licenses are held by the former medical dispensaries.
Correct.
Yeah, so that's what I'm wondering. Are they part of your?
No, yep. Our membership reflects, and we vet our members, so they reflect small, independent businesses. Yes.
There is a new, just to follow up on that, there's a new retailer in Bennington that, I think it's in Bennington, that also operates retail in another state, Massachusetts. Would they be members? Would you accept them into your organization?
I would need to confer with my development director, but I'll say this. What's common in the adult use industry in this country, there's something called this acronym MSO. You may have heard of this acronym MSO. That stands for multi-state operator. There are large behemoth multi-state operators with that operate in several dozen states. There's about 20 regulated adult use cannabis states right now in this country. And so these multi-state operators, there's large corporations like Curaleaf, Ianthus, you may have heard of some of these MedMen. And then also what we are seeing more recently is the emergence of more regional multi-state operators. So they maybe hold licenses in just 2 or 3 states and not 20, right? And so that's what we're seeing here in Vermont as well. Not just these large actors, but these more regional MSAs. So we're for independent, right, Vermont businesses and keeping dollars local as much as possible. So that's how I would respond to that.
So you had mentioned the term integrated license. Now, please correct me if I'm wrong, but my sense is that none of those integrated licenses were actually applied for and purchased. That the MSOs operating the 5 medical dispensaries didn't buy those. And that's why we don't have a social equity system as a result.
Good question. So one of them just got approved, totaling 3. So there are 3 integrated licensees currently. One is Ceres. You may have heard of them. Ceres is based out of Burlington. They were purchased by Slang Worldwide, which is a Canadian multi-state operator, one of these more larger companies we're talking about. So Ceres is no longer a Vermont independent company. The other one is Vermont Patients Alliance, which I believe is in Montpelier, and that's owned predominantly by Curaleaf. And then the one that was just licensed, I believe, this past week is Grassroots Vermont, which is owned by Ianthus. Ianthus is another one of these larger MSOs. So all 3 now have integrated licenses.
And those were $100,000 licenses?
Correct.
Okay.
And the connection, just maybe you can make it, David, between those licenses and the social equity.
I believe that the social equity measures, correct me if I'm wrong, were supposed to be funded by those fees collected. Is that right?
A one-time fee from those licenses. And we want that to be ongoing. We think that should be a funding source.
John.
How far are we from, say, a cultivator having a farm shop, being able to sell, accessory on farm business sort of thing?
How far away are we?
Yeah, like,
I would like to know that too. I think our constituents, the members of our organizations would all like to know that. I think it's been said rather hyperbolically as we've talked about this in the State House, that this isn't the same as growing tomatoes. And I think everybody knows that. And I don't think we need to use that expression anymore. We brought forth language, and I believe Representative Templeman also supported bringing forth language with Representative Serpernat this year, which would have essentially asked the Cannabis Control Board to articulate scale appropriate regulation for the direct sale of cannabis from some of the smaller tiers, indoor, mixed, and outdoor licensees. The conversation has essentially been that from what we've heard from them and from others, that they do not feel like it's a politically viable statutory change to try to make right now in the State House. And that they may or may not have the capacity to sort of administer a program like that. We have, of course, supported adequately funding the Cannabis Control Board from the beginning. We continue to do so. So I would love to know more. That's a great question. We've always been advocating for that. We think it's a significant, right now, the marketplace, we would characterize it as providing a lot of market power to the retail side of this, and really taking a lot of market equity away from producers and manufacturers, the actual people growing the plants, the actual people making the products. There are, conversations, it sounds like at this point, happening between retailers and cultivators and manufacturers about right price points, but ultimately, those wholesalers and retailers are the only people that manufacturers and producers can sell to right now. So they're sort of beholden to them in terms of ultimate price point and process. And from our perspective, a lot of the legacy or underground, they've relied on direct sales and direct relationships for decades. And they probably will continue to. And I think that's one of the things we see as a critical threshold for the state actually bringing a lot of them in, is beginning to allow a lot of them to continue those direct relationships with the people they've been serving for a long time.
Thanks, Vinny. Add to that, one of the things we would like to avoid is looking at more mature states that have had these adult use markets for 5, 6, 7 years. If you look at those states, their state houses are now contemplating, deliberating things like bail allowance for their small producers in their cannabis markets. Because of this inequitable market structure, they just do not have access. They cannot form a relationship with customers. We're trying to prevent that. We're trying to get ahead of that. So.
All right. Thank you. And if we get the actual bill, take testimony, we'll look you up again. Thank you.
Yeah, I appreciate the conversation.
Thanks, Vinny.
All right.
So let's.
We can do that one. I might both be in these, actually.
We have to get the floor at 2:30. Why don't we take a little break? Don't go off into town.
I get lost.